Council meeting of March 26, 2020 at 11 a.m. is via teleconference. I am Wade Carpenter. I am the chair. Also in attendance is post-council staff, post-council director Scott Stevenson. I'll go ahead and do a call-in. As a matter of housekeeping issues, make sure that if you make a motion that you state your name and if you're in favor or opposed, and then we will add that into the record. So when I call for the order, you will say, for example, Spencer Austin in favor, and then we'll kind of move through that so we can check it off. Make sure every time you make a motion that you're very clear on who it is, and I will acknowledge that. Director Stevenson, anything to add?
Yes.
Yeah. Hold on.
So, Chief, this is Chris Fielding from Post. I need to remind our Post Council members who are listening that they need to self-mute their phones until they are asked to speak or need to speak, so we do not get feedback. And that includes any legal counsel listening in at this time. So just a reminder, self-mute, and when you need to talk, remember to unmute and then mute again. Thank you.
Hey, Chief?
Yes, sir.
Just ignore that last text since you're giving me time now. What I'd like to do is have Marcus Yockey explain why Post Council is being conducted under such conditions.
Absolutely.
So,
go ahead, Marcus.
Thank you, Chief. So in regards to the executive order that was provided by the governor in regards to the suspension of certain rules for the Open Meetings Act, the Public Open Meeting Act, we are allowed to conduct this telephonically. The Utah Department of Public Safety already had a regulation in place that allowed for telephonic meetings. We've already had a few meetings with Post Council before, but this suspended the requirement to have an anchor's location as well as certain notifications. However, this meeting will still proceed as normal and will satisfy any due process concerns.
Any questions for Mr. Yockey? With that, we'll go ahead and move forward. Anything else, Director?
nope, Chief, we're good.
All right. I'd like to call for a motion for approval of the December 4th, 2019 minutes. Do I have a motion? Please state your name.
Oh, yeah, we need to do a roll call first.
Oh, wait.
Oh,
Hey,
sorry.
Chief.
Roll call. Got it.
You got to verify.
Okay, I'm going to start with the roll call.
So we have a quorum.
Spencer Austin.
Here.
Bruce Bailey.
Here.
Frank Budd.
Here.
Dr. Matthew Checkitts.
Here.
John Crowley.
Present.
Nathan Curtis. Sheriff Curtis.
I'm here.
Mike Haddon.
Here.
Victoria McFarland.
I'm here.
Christy Morin.
Here.
Sheriff Noel.
I'm here.
Sheriff Pulsifer.
Here.
Colonel Rappage.
Here.
Chief Soap.
Here.
And Chief Swanson.
Here.
Thank you. I'll now move to approval of December 4th, 2019 minutes. Do I have a motion for approval?
Spencer Austin, I'll make that motion.
I have a motion from Spencer Austin. Do I have a second?
Mike Haddon, second.
Mike Haddon, Director Haddon. Do I have any further discussion? Hearing none. All those in favor?
Aye.
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 I'll
Aye.
go through.
No, we're fine on this.
Now.
Chief, on this one, fine, because as long as
Okay. All right.
it's not...
Do we have any opposed? State your name if you're opposed. I think we're good. At this point, we'll go ahead and turn over to disciplinary cases with Linda Beatty.
Okay, good morning. The first case is Neil Anderson. Is there an attorney present for Mr. Anderson, or is he present? Is Neil Anderson present? Okay, it appears that Mr. Anderson is not present on this call, and no attorney is present for Mr. Anderson on this call. In this case, the sustained allegation is false publication of a government document to obtain certification, possession, or use of a controlled substance. The guidelines call for a baseline of 2 years. Post recommended 3.5 years. The baseline was 9 months to 3.5 years. In this case, there was an aggravator of a previous post-discipline, which was in August of 2017 for wrongful appropriation. Mr. Anderson received a 3-month suspension for that charge. Another aggravator is that there are multiple charges. There are no mitigators. He has 12 years of service. On April 19, 2017 and August 9, 2018, Neil Anderson falsified government records, and in 2016, Anderson possessed or consumed a controlled substance. In the 2017 application for employment with a local police agency, Anderson disclosed stealing 1 television and no drug use. In the 2018 application with the same agency, Anderson disclosed eating a marijuana sucker in 2016 while he was employed with the Utah Department of Corrections, and that he had stolen 2 televisions. During a Garrity interview with Post, Anderson only confirmed he had ingested marijuana after investigators made multiple inquiries and pointed out inconsistencies in statements. Anderson admitted to consuming marijuana on more than 1 occasion while still working for the Utah Department of Corrections. When Anderson was asked why he did not disclose the information in the 2017 application, Anderson said he feared it would have prevented him from getting a job. The theft of the televisions was investigated by Post in 2017 and resulted in a 3-month suspension for wrongful appropriation, which I've already stated. Anderson failed to respond to the notice of agency action, and an order of default was entered. And that's it. Mr. Anderson is not here. No counsel is here.
Before we proceed, for the record, Director Haddon, I'll have you recuse yourself. Is that correct?
Yes, I will. Even though he's not employed with us, I was involved in that prior case, so I recuse myself.
Thank you, sir. With that, I will go ahead and ask for a motion.
This is Bruce Bailey.
I would like to make a motion to accept Post recommendations.
I have
Bruce Bailey.
Okay, Bruce Bailey, go ahead, sir.
I'd like to make an alternate recommendation to move from 3.5 years to revocation, given the history and the behavior outlined in the complaint.
So we have a alternate. Oh, go ahead, Linda.
It's Christy Moore, and I was going to second the alternative.
Okay, so just so I can keep this straight here. So that was Bruce Bailey is making an alternate recommendation.
And just for clearance, it would be a substitute motion.
A substitute motion to ask for, sorry, I missed what it was again.
I can change it from a 3.5 year suspension to revocation.
A 3.5 year, so we have a substitute motion changed from a 3.5 year to a revocation.
Yes.
Bruce Bailey. And I have a second on that from Christy Moore, is that correct?
Yes, sir.
And I'm going to do a roll call. All those in favor, I'm going to start with Spence Austin.
Aye.
Bruce Bailey.
Aye.
Frank Budd.
Aye.
Matthew Checketts.
Aye.
John Crowley.
Aye.
Nathan Curtis.
Aye.
Mike Haddon.
I'm recused.
Recused. Christy Moran.
Aye.
Cameron Noel.
Aye.
Corey Pulsifer.
Aye.
Mike Rappage.
Aye.
Chad Soap.
Aye.
And Alan Swanson.
Aye.
There's no one is opposed. Any further discussion?
Did we get Victoria McFarland?
Oh, did I miss Victoria? Sorry, Victoria McFarland.
Aye. Thanks.
Sorry, Victoria, I missed that somehow. Is there any further discussion? And then any opposed? Hearing none, motion passes. Go to our next.
The next case is Jordan Bradford. Is Mr. Bradford present or is counsel?
Jeremy Jones for Jordan Bradford, present.
Is your client present, Jeremy?
Jordan Bradford's present as well. Sorry, that's on mute.
Okay. Okay, thank you. In this case, the sustained allegation was criminal mischief. The baseline calls for a 6-month suspension. The range is a letter of caution to 1.5 years, and postage recommending a 6-month suspension. Mr. Bradford, at the time of this occurred, was a Department of Corrections employee. He had 7 years of service. He separated with Department of Corrections in June of 2018. There are no aggravators. He resigned from his department. This case occurred on February 24th, 2018, when Jordan Bradford, who at the time was a supervisor at the Utah State Prison, entered a supply room where one of his subordinate officers was having a conversation with 2 inmates. Bradford selected toothbrushes from one of the supply shelves and began sharpening them to a point on the concrete floor. Bradford then used a lighter in an attempt to melt the toothbrush to a point. Bradford also provided one of the inmates a toothbrush so the inmate could sharpen one to a point. After suggestion from the inmate, Bradford allowed one of the inmates to use the stove in the kitchen to heat the toothbrush to a point without supervision. Bradford eventually joined the inmate in the kitchen where the weapon was being manufactured by twisting 2 toothbrushes together to a point. Bradford secured the manufactured weapons and they were disposed of in a garbage receptacle inside a control room. Charges were not filed against Bradford. Criminal charges were not filed against Bradford. However, an internal administrative investigation determined his conduct was unlawful and he resigned on June 30th, 2018. During Garrity interviews with Post and his agency, Bradford admitted he manufactured the weapons. However, he did not consider them to be dangerous because he, in his opinion, the manufacturing process had not been completed. On December 11, 2019, a hearing was held before an administrative law judge. The administrative law judge issued findings of fact and conclusions of law, stating that Bradford violated 53.6.211 with respect to count 2, criminal mischief, I think. However, the ALJ did not find convincing evidence to support that Bradford violated count 1, which was manufacturing, which was prohibited weapons inside a correctional facility. And that's it. Would Mr. Jones, would you like to speak, or your client?
I would, yes. I'm sorry, but somehow we lost the call right as you started, Linda. We just picked up right as you were reciting the ALJ's findings relative to the case. So we're a little bit in the dark, but I'm not sure that's really going to matter. I think all I would ask the counsel on this is that count 1 was rejected by the ALJ. I don't believe that those facts are appropriately considered here. The only count that was sustained against Mr. Bradford was count 2, and as the ALJ put it, he ground down a toothbrush. That is, in the ALJ's word, a minimal value, and it meets the lowest level of the statute. With the recommendation being 6 months, given the ALJ's qualifications about the factual circumstances surrounding this count, and in essence, the de minimis nature of what occurred, we would ask the counsel to consider issuing a letter of caution under the circumstances. With that being said, I'll let my client Jordan speak to the counsel.
So I'll make this brief. I know you guys have a lot to do. I just wanted to say that I made a mistake. I've been honest with LED and Post. I'd ask for leniency as well. I've had many months to reflect on this, and I'm sorry for what I did, and that's it.
Anything additional? Mr. Jones or Mr. Bradford?
I believe that's it. Again, we're a little bit in the dark because we missed what you said, but I think we covered the bases that we expected to cover. If there are some current concerns from the council that they feel we didn't address, I'd like the opportunity to address that. Otherwise, we can let the council vote.
Council, if you have questions, please state your name.
Alan Swanson. Mike Haddon. I've got to recuse myself on this case.
For the record, please show Director Haddon is recusing himself.
Alan Swanson, question.
Go ahead, Chief Swanson.
Where Jordan resigned back in 2018, even if council goes with the 6-month suspension, wouldn't that time already be served?
Yes.
Is that Mr. Yaki, for the record?
That's Scott. Sorry, Director Stevenson. Director Stevenson. This is Marcus. Yes, I agree with Scott's analysis.
Okay, then I would make a motion. This is Alan again. I would make a motion to go ahead with post recommendation.
So we have a recommendation to follow post recommendation from Chief Swanson. Do I have a second?
This is Frank Budd. I'll second.
I have a second from Frank Budd. Any further discussion?
Yes, Director. This is Jeremy Jones for Jordan Bradford.
Mr. Jones, please go ahead.
Thank you. I understand that the time is already served in so far as post guidelines on implementing those suspensions, and the general momentum would be to approve post recommendation. But I would ask the council to carefully consider a letter of caution here, given how minimal this conduct is. That will have meaning relative to my client and relative to his future job prospects. That he received a letter of caution over a suspension, and I think that that's appropriate when all we're dealing with is the grinding of a single toothbrush. Thank you.
Thank you, sir. Any questions?
For the question.
Please, Chief Self.
If I can just ask Jordan, what was your intent? Did you not understand that grinding of a toothbrush could be used as a weapon in the prison, or can you explain that to us?
Sure, like I had explained to Post and LEB, at the time I had an extra officer with me. We had a inmate that was volunteering information that usually they'd keep quiet about. I had thought bringing another officer and being on camera that we'd covered our bases. It was a Sunday, I believe. And so I was the OIC of my facility and thought that if we had taken this, after he showed us how they're making it and just take it, we could then make a vulnerability training about this. So that was my intent at the time. And as I said, I really recognized that this was a grievous mistake.
Okay. Bruce Bailey.
Go ahead, Mr. Bailey.
I would counter argue that he provided an inmate with a potential weapon that could have been used against officers. So a 6-month suspension is being generous, in my opinion.
And this is Linda Vitti. I just want to make sure the record is clear that it wasn't a single toothbrush. That's not an accurate reflection of the facts that were found at the hearing.
Any further questions?
This is Jeremy Jones. I'm sorry. I'm going off of the ALJ's findings. The findings were, quote, he grabbed a toothbrush out of boredom and began grinding it on the floor of room 9. He was intentionally destroying UDC property for no good purpose. And so the findings before the ALJ are a single toothbrush. The allegation that this constituted a weapon was dismissed by the ALJ. That is not appropriately considered by the council.
Okay, Jeremy, I agree that with respect to you are correct that with respect to the finding of criminal mischief, the judge may have only been referring to one toothbrush, but that's true. With respect to that charge, that may be what he found.
Any further questions? Mr. Jones or Mr. Bradford? So we currently have a motion from Chief Swanson to go with 6-month suspension and a second from, I believe it was Frank Budd. Is that correct?
Yes.
Do we have, I'll go ahead with roll call. Spence Austin?
Aye.
Bruce Bailey?
Aye.
Frank Budd?
Aye.
Matthew Checketts?
Aye.
John Crowley?
Aye.
Nathan Curtis?
Aye.
Mike Haddon, I was recused. Victoria McFarland?
Aye.
Christy Moran?
Aye.
Cameron Noel?
Aye.
Mike, Corey Pulsifer?
Aye.
Mike Rappage?
Aye.
Chad Soap?
Aye.
And Alan Swanson.
Aye.
Seeing none opposed, the motion passes. We'll now have our next, I think it's Jordan Bradford. Oh, sorry, Silver Brown.
Chief Carpenter, Alan Swanson, I have just a quick question.
Go ahead, sir.
This is probably more for our legal team to answer, but just for the sake of time in the future on these, instead of doing a roll call for aye, can we just do anyone opposed? And then
Yes,
assume?
we can.
Okay.
Is that okay then? So I can just ask for opposed, is that correct?
Yeah, and then just verify who has been opposed. And so you could ask for, if there's, just ask for a vote and then ask if there's any opposed and then identify who is opposed to it.
Okay, thank you.
Thanks.
Ms. Beatty?
Okay, this is Linda again. The next case is Silver Brown. The sustained allegations in this case were lying under Garrity, falsification of a government record, and theft. The range is 3 years to revocation. The baseline is revocation and post-recommend revocation. At the time this occurred, Silver Brown was employed by the Utah Highway Patrol. He's currently employed, I believe still, unless something's changed by DYU police. He had 16 years of service. He resigned from the Utah Highway Patrol. On or about July 5th, 2018, Silver Brown was investigated by his agency for discrepancies on his daily logs and timesheets throughout multiple days. Oh, I'm sorry. Let me just back up for just a moment. There's an aggravator in this case, and the aggravator said he had a previous post case. It was a BCI violation that resulted in a letter of caution in August of 2016. The other aggravator in this case is that there are multiple charges, I believe, multiple counts. So on or about July 5th, 2018, Silver Brown was investigated by his agency, then Utah Highway Patrol, for discrepancies on his daily logs and timesheets throughout multiple days. The investigation determined that Brown had completed inaccurate daily logs on March 29th, 2018, April 2nd, 2018, June 1st, 2018, and June 19th, 2018. The investigation further disclosed that Brown lied to his division commander on July 19th, 2018, OPS on September 19th, 2018, and Post on December 4th, 2018, after having been given warnings based on Garrity, New Jersey. The OPS and Post investigations verified Brown's lying about the hours he claimed on his timesheets. Silver Brown waived his right to a hearing on December 18th, 2019, and stipulated to the facts contained in the notice of agency action, and that's it. Mr. Brown, are you present, or is Mr. Skordas or another attorney present for you?
We are both here. This is Greg Skordas, and I have Silver Brown in the conference room with me. Thank you.
Would you like to be heard?
Yes, thank you. I think I'd like Silver to just address some of these issues briefly. We did waive the hearing, but I wanted the council to hear from him why we don't consider these to be lies under Garrity, and I'll let Silver address them. And I told him to keep his remarks brief.
Thank you, Post Counsel. On the March 29th issue, the 2-hour public presentation, that was a presentation that was done at a Dixon Middle School in Provo for my daughter, and I had mixed some of those details with other presentations that I've done in the past, and so details weren't clear to me at that time. These, again, just to back up, at the time of the interview, all the allegations were 4 to 6 months prior, and so it was very difficult for me to try and remember details that the interviewers were asking for. On March 2nd, the 2-hour April 2nd, the 2-hour driver's license hearing, it was a normal practice of mine to attend the hearing at the driver's license office in Orem. On this particular day, I created a log for a 2-hour hearing, which is normal for being present at the hearing. But due to some circumstances at home, I was not able to attend, so I called in, did a telephonic hearing, and forgot to change the logs to a 1 hour instead of 2 hours. And that was I believe it was a simple mistake there. The other original allegation were on April 3rd and April 4th, traveling to overtime shifts and stopping vehicles on the way to the overtime shifts and claiming those times. I was told by past supervisors that any enforcement done to and from overtime shifts that I need to claim those hours. And it was mentioned by the investigators that was something that I did all the time, and it was not. They were only able to produce 2 instances of all the many overtime shifts that I've worked. On June 1st, a driver's license hearing, that it was alleged that I did not attend, and I was very adamant that I was there. I remembered the case and that I attended the hearing. Well, the interviewers or the investigators were very adamant that I was not there, and they accused me of lying that I was not at the hearing because they had done their investigation. Well, a day or two later, they texted me saying that, it was in fact that I did attend the hearing and that there's proof that I was present. On June 19th, the hours that were allegedly claimed for training, those were all during regular shift. And so those were not claimed in any fraudulent manner. Those were all during regular shift, and the training hours there were only claimed for training hours. Post counsel, the only thing I can honestly say that because I mixed up details that I was trying to pull from 4 to 6 months prior, that's the only reason that I mentioned to the captain at that time that I lied to him, because I was mixing up information, and that is the honest truth. It's not me. If you look at my history, my nearly 16 years of service, nothing like this has occurred. It's been nearly a year and a half since I resigned, and it's been a tornado. It's been in any way, I apologize. I plead for your mercy, for your understanding, and I just like to get back to something that I really enjoy and love and good at. And with that, thank you so much for your time.
Thank you, Mr. Brown.
This is Linda Beatty. May I be heard?
Ms. Beatty, go ahead.
Yes. Since Mr. Brown has now given another version of the events, would it be permissible for me to read from his previous interviews which contradict the current statements that he has now made to Post Counsel?
Please proceed.
Thank you. With respect, and I'm reading from a recorded transcript. With respect to the incident on June 19th, 2018, when he claimed to have been working on training bulletins for 8 hours and 58 minutes, he was asked at 54:10 in the interview, "Were you making up time?" His answer, "I believe I may have." At 54:26, he was asked, "So you weren't working those hours? You were falsifying your data logs and you were falsifying your time cards?" His answer, "Correct." Question, "For this day?" "Yes." Let me continue, please, unless you don't need to hear any additional. Question at 54:57, "Have you done this in the past?" Answer, "Probably." Question, "Why would you make up time? What was the reason?" Answer, "My guess would be to avoid using annual leave, sick leave, excess. That's my guess. That's probably what happened." Question, "So that's what happened on June 1st as well?" Actually, I didn't have his answer recorded on that one. Sorry. At 100.02, he was asked, "Let me be brutally succinct. Did you lie to him," referring to Captain Nyber, "about what happened, about what you did on that day?" Answer, "Yes." Would you like me to continue? Or at 102:45, he said, "Did you complete any DTBs on June 1st? Answer, "No." I can continue for quite a long time on this, but I think Post Counsel gets the point. Mr. Brown has presented yet another, so we were in the fourth version of the facts now today.
Any questions for Ms. Beatty? Hearing none, I'll ask for a motion.
Mr. Chair?
Yes, go ahead.
This is Colonel Rappich. I'm going to recluse myself.
For the record, please show Colonel Rappich has recused himself, as he's the Colonel of the Highway Patrol.
Do I have a question for the trooper or his counsel?
Pardon?
This is Sheriff Noel. I have a question for the trooper or his counsel before we go forward with the vote.
Yes, sir.
Oh, go ahead. Who's answering?
We're both here, so we'll answer.
I would like you, counsel, or or the trooper to respond to Mrs. Beatty to what she just said. Why did you admit to those things?
Sir, I did not have all the details with me at that time. I was not. I admit my logs weren't accurate, and that's my bad. All of it weren't documented, but I believe going back to my schedule, June 19th, that was a regular shift up at the state capitol and logging DTBs throughout the shift. And I tried to see if the Discovery printed that out, and they did not. And also, it did not reflect on the time card copy that was provided in the Discovery. And so, why did they leave that out? I don't know. But that's my recollection when I went back to my records to see where I was on that day, and it reflected that I was on a regular shift up at the state capitol, working a regular shift and also working on training bulletins throughout the shift. And that's why it reflected, but they were not, it's very different from what I did say that day, but again, I did not have all the details with me or my logs or accurate logs or my calendar to show where I was and what I was doing.
If I may
Thank you.
point out, the video indicates that, in fact, Captain Nyber provided the logs to then Trooper Brown, and he had the logs with him during the videotaped interview.
Yes, I did have the logs, but again, like I said, my logs weren't accurate, and there were a lot of missed information there. So that's on that.
This is Victoria. I have a question.
Please, Victoria.
So, am I understanding correctly that the position today is that your logs were not accurate at the time, and that was it seems to be a recurring type of issue, and because your logs were not accurate, you were not accurately inputting information, that somehow led to some confusion that should now, for whatever reason, be a mitigating factor?
Well, this is Greg Skordas. It's certainly not a mitigating factor. He's owned the fact that his logs were inaccurate. But if you read the investigative report, he's confronted with the inaccuracy of his logs and then is told, so therefore you must have lied. And he says yes. But as we look at it now, after reviewing all the facts, he was wrong. His logs were wrong. His statements were wrong, and he's owned that. But I think that's significantly different than just outright lying about it. But when he's confronted and said, so you're wrong, you lied, he says yes, because he's thinking of it different than the rest of us do. And I just don't think that this was someone who was lying to an investigator, but is someone who is looking at something that occurred several months earlier and saying, you're right, I did that wrong. And I would it's not mitigation, but it's certainly not a falsification or a lie.
But he's given multiple opportunities, right? He's given an opportunity with the documentation to review this with the captain, and then a period of time goes by, and then he's approached by professional standards. So it's not like this all happens together. There was some time in between the interaction with the captain and professional standards where he was put on notice and had the opportunity to, kind of gather his thoughts, gather information, and then with that acknowledges to professional standards that he's lied.
Yes, ma'am.
This is Silver Brown speaking.
Sorry. So the original allegations there were three. There were the March 29th, the April 2nd, and April 3rd, and April 4th, which those were together. After those original allegations, then I was questioned later about June 1st and June 19th, which I had no idea or no knowledge of from the original allegations.
A question from Christy Moore.
Go ahead, Christy.
Mr. Brown, were you given any training or progressive discipline about the misunderstanding, or did it go straight to investigation?
It went straight to investigations. After the original allegations that I wrote a memo about explaining what they were, and that's what I was questioned about. And then later on, I was questioned about two separate incidences that they went ahead and looked for and found. And from there, it went straight to professional standards.
This is Linda Beattie. Let me just read into the record one more time something I stated already, just to clarify everything.
So if you've already stated it already, why do you need to read it again, Linda?
Because I think
you've made your position as crystal clear as you can.
Well, I would ask everyone who's listening then to refer back to what I stated occurred at 54:57. Why would you make up the time? What was the reason? My guess would be to avoid using annual leave, sick leave. That's all I have to say.
Thank you. Any further questions? Hearing none, the post recommendation is for revocation. All those in favor?
We need a motion.
Do I have a motion to accept the post recommendation?
Or any motion.
This is Christy Moore. Can I make a motion?
Yes, go ahead, Christy.
I'd like to make a recommendation for 3.5 year suspension rather than revocation.
So I have a recommendation for a 3.5 year suspension versus revocation. Do I have a second?
Victoria, I second that.
I have a second from Victoria. Any further discussion? Hearing none, I'll go ahead and call for the vote and then ask if anyone is opposed. Actually, is there anyone opposed to that? Hearing none, all those in favor?
Aye.
Aye. Aye.
Aye.
The motion passes. Thank you. Next is Joseph Hawes. Ms. Beattie?
Yes. Next case is Sean Fox, I believe.
I think, let me see if I've got, Sean Fox, sorry about that.
Okay, Sean Fox. Is Sean Fox present or is the counsel present? Okay, Sean Fox has not responded. No counsel has responded for Sean Fox. The sustained allegations are written false statement, willful falsification of an application to obtain certification. The guidelines baseline are 2 years. Post recommends 2.5 years. The range is 9 months to 3.5 years. Mr. Fox was employed by the Syracuse Police Department. He separated in November of 2019. He was terminated by his department. He had 3 years of service. Sustained allegations are written false statement, willful falsification of an application to obtain certification. He was investigated November 21st, 2019. In October 2019, he completed an application for the Syracuse Police Department and an application for post. Both applications asked questions about Fox receiving discipline from any former or current law enforcement agency that he has worked for. In December 2018, Fox received a verbal warning from the law enforcement agency he was working for. On July 31st, 2019, Fox received a written warning from the law enforcement agency he was working for. Fox did not document his warnings on his post application or his Syracuse police application. In November 2019, Fox admitted to receiving verbal and written warning. He admitted he did not document the verbal or written warning, and an order of default was signed. He did not respond to the investigation. I have nothing further.
Thank you. Any questions for Ms. Beattie? Hearing none, I'll go ahead and ask for a motion.
Mike Adam, I move to support the post recommendation.
I have a motion from Director Haddon to accept the recommendation from post.
Sheriff Pulsifer, second.
And Sheriff Pulsifer for second?
Yes.
Any further discussion? Hearing none, do we have all those in favor?
Aye.
Aye.
Any opposed? Seeing none opposed, the motion passes. Next is Joseph Hawes.
Is Mr. Hawes present, or is counsel for Mr. Hawes present?
Hawes present.
This is Joseph Hawes. I'm present.
Hey, I'm sorry, is counsel present for you, Mr. Hawes?
Negative, just myself.
Okay, thank you, sir. The sustained allegations in this case are falsification or alteration of a government record and official misconduct. The guidelines call for 1 year. Post recommends 1.5 years. The range is 3 months to 2.5 years. The officer was working for the Utah County Sheriff's Office, but he transferred to Pleasant Grove prior to the investigation. He had 4 years of service. He's currently employed. Joseph Hawes was investigated for missing property. The investigation disclosed Hawes did not properly handle citizens' property on multiple occasions. The investigation disclosed Hawes documented in his report that he booked a coin that had been turned in as found property. Weeks later, while cleaning out his patrol car, Hawes found the coin in his vehicle and chose to throw it in the trash. Hawes did not document his actions. Another instance involved a necklace belonging to a female who had been arrested earlier. The necklace had been overlooked the night the female was arrested. The necklace was placed in an envelope given to Hawes. Hawes attempts to contact the female but was unsuccessful. Hawes told his department that it may have been thrown away. The internal investigation determined Hawes had not been completely truthful. During the post-Garrity interview, Hawes confirmed he had reported he had booked the coin into evidence. Hawes said he recognized the coin when he found it in his car weeks later and chose to throw it into the trash. Hawes was also asked about the necklace. Hawes confirmed he had been given an envelope containing a necklace that belonged to the female he previously arrested. Hawes stated the envelope in his vehicle, located the envelope in his vehicle weeks later and threw the envelope in the trash. The two incidents occurred on different dates. When asked why he threw the two items away, Hawes stated he was afraid others would find out about his improper handling of the evidence and feared being teased about it by fellow officers. He failed to respond to the notice of agency action. Order of default was entered against him. I have nothing further.
Any questions for Ms. Vitti? Hearing none, do I have a motion?
We want to hear from Joseph.
Is he there? Sorry, I missed that. Is Joseph, are you there?
Yes, I'm present.
Sorry about that. I didn't realize you were on one. Go ahead.
You're okay. I would just like to be heard a little bit. I understand what was how the investigation played out. I just want to state on the record that I am sorry as to how this has played out. I realize that my actions were negligent, and I don't know how else to say it other than I'm sorry. I don't exactly feel like it's justified to suspend me for 1.5 years. It was a mistake. I feel like I'm a good cop. I loved my job. I have no hard feelings towards law enforcement or how the investigators conducted themselves. I just want to make it stated on the record that I am sorry, and if you guys could find it in yourself to have mercy on me, I would ask that you guys do a letter of caution versus a suspension. And that's it. And my lesson is definitely learned. If my fear of being teased does not outweigh what should have been done.
Any questions? Any questions for Mr. Hawes? Ms. Vitti, anything additional?
I have nothing additional.
Do we have a motion?
Chief, Sheriff
Yeah.
Noel, I don't have the guidelines here. I'm looking at the case and trying to go back and forth on my computer. What is the next level below the 1.5 year suspension on the guidelines?
I don't have those in front of me. Do you have the Director Stevens?
The minimum was 3 months.
Sheriff Noel makes a motion for 3 months.
I have a motion for 3 month suspension. Do I have a second?
Wait a minute. Hey, just so the council knows, this is Director Stevenson. It's a Category D. The range is 9 months to 3.5 years.
Okay. So for clarification, it's not 3 months. Does that change your motion, Sheriff?
Yes, it does. So 9 months. I'll make the motion for 9 months.
This is Category C here.
So I have a motion from Sheriff Noel for a 9-month suspension. Category.
Hey, sorry. Sorry, my bad. It's Category D. Strike that.
So Sheriff Noel, this is Marcus Young. It is 3 months to...
Stevenson. Okay.
Sorry, Chief.
Go ahead. Just so I'm clear who's talking.
3 months to, so it's a Category D, 3 months to 2.5 years is what our range is.
And that's Category D, correct?
As in Delta, yes.
Delta.
Okay. Sheriff Noel, would you like to make a
No,
motion?
I think I'm gonna keep my motion at 9 months.
So I have a motion for a 9-month suspension from Sheriff Noel. Do I have a second?
John Crowley, I'll second it.
I have a second from John Crowley. Any further discussion? Hearing none, I'll go ahead and ask for the vote. All of those in favor?
Aye.
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 Do I have any opposed? Hearing none, the motion passes. Thank you. The next is Roger Hill.
Is Roger Hill present or attorney for Roger Hill present? Roger Hill is not present. No counsel is present for Roger Hill. The sustained allegation in this case is possession of a controlled substance, possession of drug paraphernalia. The guidelines, it's a Category C and E. The guidelines call for a baseline of 2 years. The range is 9 months to 3.5 years. Post is recommending 2.5 years. Mr. Hill has 12 years of service. The aggravator is that there are multiple charges. In the criminal case, he pled guilty to possession of a controlled substance and possession of drug paraphernalia, both Class C misdemeanor. He was terminated by his agency, the Twilla County Sheriff. Roger Hill was investigated by a local police agency for assault, possession or use of a controlled substance, and possession of drug paraphernalia. The investigation disclosed that on August 6, 2019, Hill was involved in an argument with his wife. During the argument, police arrived on scene. Hill's wife told police that Hill used steroids. The local police agency located 6 vials of steroids and 1 syringe that was used to inject the steroids. Hill admitted to the local police agency that the steroids and the syringe were his. The assault was unfounded. The case was screened to the local county attorney, and charges were filed on Hill for possession or use of a controlled substance and possession of drug paraphernalia. Hill entered a plea in abeyance to the charge of possession or use of a controlled substance and possession of drug paraphernalia. During the Garrity interviews with both his department and post, Hill admitted to using steroids. He admitted that the steroids and syringe located by the police agency were his. He said he used the steroids to get ready for a bodybuilding competition. An order of default was entered against Mr. Hill. I have nothing further.
Any questions for Ms. Vitti? Hearing none, I'll call for a motion. Oh, go ahead.
Chad Soap, I'd make the motion to follow post recommendation for 2.5 year suspension.
So I have a motion from Chief Soap for a 2.5 year suspension. And I have a second from, sorry, I didn't catch who that was.
Sheriff Pulsifer.
Sheriff Pulsifer, thank you. Any further discussion? Hearing none, I'll go ahead and call for a vote. Those in favor?
Aye.
Aye. Any opposed? Hearing none, the motion passes.
The next case is Charles Hoffman. Is Mr. Hoffman present or counsel for Mr. Hoffman present?
Counsel Rich Willie and Mr. Hoffman are both present in the same room.
Thank you. The sustained allegation in this case was lying under Garrity. The baseline is revocation. The range is 3 years to revocation, and Post recommends revocation. Mr. Hoffman was employed by the Box Elder County Sheriff's Office for 26 years. There are no aggravators or mitigators, and there was no criminal case. In May of 2018, Charles Hoffman was investigated by his department for questioning officers from a different department about a conflict case the other department handled. During a department Garrity interview, Hoffman only admitted to speaking with 2 officers from the other agencies about the conflict case. Hoffman denied speaking with other officers about the conflict case or attempting to obtain information about the case. The IA identified 4 additional officers Hoffman had spoken with inquiring about the conflict case. A second Department Garrity interview was conducted with Hoffman. He had admitted he brought up the topic of the conflict case to 3 or 4 officers who were identified after the first Garrity interview. Hoffman explained he asked one of the officers one of the officers when the date and time of the incident was because he could not locate the information in the department report management system. Hoffman asked the second and third officers something about what happened during the conflict case, but he did not recall any specific details. The Sheriff's Office sustained the allegation of lying under Garrity, and in September of 2018, Hoffman retired from the Box Elder County Sheriff's Office. A hearing was held before an ALJ in December 2019, and the findings of fact and conclusions of law stated that, in fact, Mr. Hoffman had, the judge did sustain the allegation of lying under Garrity. And nothing further. Mr. Willie or your client, would you like to speak?
Yeah, this is Mr. Willie, attorney for Mr. Hoffman. This case really has 2 significant issues for review. First, the first big issue, and not touched on by counsel for Post, is this case within the subject matter jurisdiction of Post? That is, does Post counsel have the authority to discipline Mr. Hoffman under these circumstances? The second issue is, did Mr. Hoffman lie during his interview? There's no doubt that Mr. Hoffman made statements that were inaccurate at the time of the interview. However, it's important to distinguish that inaccurate statements during an interview are not always equivalent to lies. In this case, Mr. Hoffman has a documented traumatic brain injury, and he also suffers from PTSD. And his therapist, Jason Williams, testified during the hearing before the ALJ that these 2 conditions in combination and in conjunction with other stressors in Mr. Hoffman's life are one way to explain how he may have forgotten to, certain details of questions that he is being asked during the interview. So I want to go to my first point first. And this is really most likely the controlling issue in the case, is whether Post has the authority to take action against Mr. Hoffman. And we know from under Utah statute that Post counsel can take action against police officers in very specific circumstances, including falsifying a certification or an application for certification, lacking mental fitness for duty, addiction to alcohol or controlled substances, engaging in conduct that would be a criminal offense, lying under Garrity, sex on duty, and the inability to possess a firearm. But it's also important to note that the Utah legislature has expressly prohibited Post counsel from suspending or revoking certification of a peace officer for a violation of a law enforcement agency policies, orders, or guidelines that do not amount to a cause of action above. So it's very clear that the Utah legislature does not want Post involved in investigating. Sorry, I have an alarm going off here, but does not want Post counsel involved in taking action against police officers based on policy violations. But the reason we're here today is because Mr. Hoffman is lying under Garrity. So before we discuss Mr. Hoffman's argument and why we don't think Post has jurisdiction in this case, I want to clarify the nature of a Garrity warning.
as you guys are aware, under the 5th and 14th Amendments of the Constitution, criminal suspects have a right against self-incrimination. But courts across the country have recognized that there's nothing inherently wrong with an employer pressuring an employee to cooperate with an internal affairs investigation or punishing somebody who doesn't. Employers sometimes need information from their employees, and private employers especially may fire an employee who refuses to answer. But in the case of a law enforcement agency, information gleaned during an interview may be used for prosecutorial purposes, and when the employer has a means to penalize the exercise of constitutional privilege, like remaining silent, this is something that's not permissible, which was why we have a Garrity warning. The Garrity warning comes from Garrity versus New Jersey, where the Supreme Court held that when a law enforcement employer obtains statements from employees under the threat of removal from office, those statements cannot be used in subsequent criminal proceedings against the employee. Now, the corollary and the takeaway from Garrity and the very purpose of a Garrity warning is that a police officer who has invoked his Fifth Amendment right against self-incrimination may only be disciplined for failing to answer questions if he is first given a warning that includes the assurance that his answers cannot be used against him in any subsequent criminal prosecution. That is the essence of the Garrity warning, and the purpose of the Garrity warning is twofold. It's to put the employee on notice that there is a penalty situation, and it creates it allows the agency to discipline an employee for invoking his Fifth Amendment right against self-incrimination. So it's well established that for a Garrity warning to apply, there has to be two critical components. The question must relate to an underlying crime, or at least a reasonable possibility of an underlying crime. And second, there must be the government must have created some sort of penalty situation or some sort of threat to compel information. The Utah Court of Appeals has recognized that police departments routinely engage in the practice of advising officers who are the subject of an internal affairs investigation that their answers will not be used in criminal prosecution, while also warning of the investigation that the refusal to answer may be grounds for termination. But the Court of Appeals has also recognized that Garrity warnings are necessary when they are only in reference to a policy violation and there's no threat of criminal proceedings. Now, this is very important to this case because the practice that law enforcement agencies or the practice of law enforcement agencies to place every officer under Garrity when they're conducting an internal affairs interview, whether or not the subject of the interview is a violation of the criminal statute, artificially extends post-counsel's authority and is contrary to the intent of the Utah legislature's prohibition on post-counsel to suspend or revoke the certification of a peace officer for violation of a law enforcement agency's policies, general orders, or guidelines of operation that do not amount to a cause of action under the previous section. So that those are the 7 or 8 things that I talked to, one of those being lying under Garrity. Essentially, what the legal framework we're looking at is when a police agency misuses Garrity warnings in an IA interview where there's no risk of criminal liability, and then later uses its authority to investigate allegations of being untruthful after lying under Garrity, it is acting outside the bounds set by the legislature because it is essentially investigating policy violations. The Utah legislature was very clear. It only wanted posts investigating these interviews when there's a criminal element.
Mr. Willie, this is Victoria Garland. Can I ask you a question at this juncture?
Yes.
Is it your position that the sheriff's office in this case that there was no possible way that they could have been that there could have been a possibility of criminal violations?
That is what the investigator testified to during the hearing before the ALJ. That was a question posed to the investigator whether, and we'll get into it contains both parts, but we'll get into why Garrity was appropriate and the scope was limited to a certain part of the interview, but for the rest of the interview, it wasn't appropriate, and based on how the interview was conducted, the rest of the interview was not under Garrity. So we can just
wait. I want to back up because I want to make sure I'm understanding your position correctly. I think that your position is that when these investigations originate and there is only the potential of policy violations and there is no potential of any type of criminal violations, it's inappropriate to issue Garrity, and thus for Post to consider any statements that may have been given under Garrity with the originating law enforcement agency, correct?
It may or may not be inappropriate to issue a Garrity warning, but it is clearly outside the bounds of Post statutory mandate to investigate those that the only underlying cause of action is a policy violation.
Okay. So, and it's your position that at the onset of this, that there is no possible way that Box Elder County could have been investigating any criminal violations.
Box Elder County partitioned their investigation, their interview, into part that was covered by Garrity, and I'll explain the reasons why I think that, and part that was not covered by Garrity. So I'll just jump into the facts because these were
and before you get there, I just want to make sure for purposes of clarity, and this is probably a question for Mr. Yaki, isn't this a legal argument that the council really doesn't have the ability to adequately address?
We thoroughly addressed this last year in our last appeal to the Court of Appeals, that the Post Council has the authority to review the order of the ALJ, and to my knowledge, that's a different issue. But that's a different issue than what you're asking us to do here. You're asking this council to essentially, the argument that's been made to this point is that Post doesn't have the authority to do anything because of X, Y, and Z. I think that is a legal issue about powers granted by the legislature. Am I wrong on that, Marcus?
So this is Marcus Yaki, legal counsel, Post Counsel. So I would agree with Miss Victoria, I was going to say Ms. McFarland. But in regards to that, this is a legal argument. And in regards to that, I believe the council should proceed with this matter. I believe on this issue we do have subject matter jurisdiction and to proceed with this.
Well, we haven't covered the facts that would indicate they don't have subject matter jurisdiction. We're only discussing the legal framework at this point.
But you've made the argument that we don't have the ability, that the council does not have subject matter jurisdiction, and now you're saying we haven't discussed the facts. That's what we're saying. Irrespective of whatever facts are that you may present, that the council does not have subject matter jurisdiction, that's a legal argument, and that's not something that is within what I believe the Court of Appeals decision or framework. I don't think that is something that this council appropriately considers.
Do you have any legal basis for making that assertion?
I do, and it's
or Post rules.
It is included in 53.6.211 sub E, which is under Title 53 of the Public Safety Code, specifically governing the Peace Officer Standards and Training Act. And it states the council has authority to suspend or revoke certification of a peace officer if the peace officer under sub E refuses to respond, fails to respond truthfully, or fails to respond truthfully to questions after having been issued a warning based on Garrity versus New Jersey. that provision provides this counsel with the ability to determine if suspension or revocation is appropriate based on a failure to answer or false information provided underneath Garrity.
Well, Mr. Hoffman answered all the questions that for the Garrity portion of the interview. The result of that portion of the interview found that he made no false statements under Garrity, and there was no policy violations or criminal violations for that.
And this is where I'm going to back up, because according to looking now at the notice of agency action, it appears that there is on February 12th, 2019, Garrity interview was conducted with Hoffman at post. He was questioned about his initial statement that he only spoke to 2 officers about the family fight during the first interview given by his department under Garrity. And then it continues to say he was specifically asked if he spoke outside to 2 outside agency officers in addition to the first 2 that he mentioned. And he indicated that, let's see, sorry, just scrolling here. And it looked like he didn't remember, but admitted the conversation with the first of the 2, but admitted speaking with the second officer.
So just for clarification, this is Marcus Shockey with Post Counsel. So this is very clearly within Post Counsel's purview, and I would.
Well, I haven't finished my argument to explain why it's not, because the county very specifically said that the only reason Mr. Hoffman was there for that interview was to question him about the veracity of a report. That was the only reason that they were there, and they induced him to forego certain rights in a statement of rights in his Garrity warning. They induced him to forego those rights based on their assertions that he was only going to be asked questions about his report. He answered the questions about the report fully. They stated they're fully satisfied with the answers they received, and as a result, that closed the Garrity portion of that interview. Anything that they asked after that, and most of what they did after that for an hour and 15 minutes was a counseling session. They weren't asking him questions; they were counseling him, and beyond that, the investigator involved testified that they were only relating to potential policy violations and had no bearing on any criminal statute. So the fact that they told him, hey, this is your Garrity interview. This is the only topic we're asking you about. They asked him about the topic. He answered about the topic. They said, we are fully satisfied with everything that we've asked you about this. Anything beyond that is not under Garrity for the purposes of post statute. Now, an agency has authority to make determinations that he lied during an IA interview for policy violations and things like that. But the questions that they asked him were not under Garrity.
Mr. Willie, you need to summarize.
Is there anything else, Mr. Willie? Because at this point, I'm going to instruct Post Counsel to continue. This is a legal argument, and if you'd like to address this later on in an appeal to the Court of Appeals, you're more than welcome to. But at this point, I believe there is sufficient information to show that this is clearly under Post Counsel's jurisdiction with the Garrity interview conducted by both. If you'll allow me to finish, sir, this is clearly under Post Counsel's jurisdiction, and with a Garrity interview both conducted at Box Elder and at Post. The law is very clear, as Victoria McFarland stated. The counsel has the authority to suspend or revoke the certification of a peace officer if the peace officer refuses to respond or fails to respond truthfully to questions after having been issued a Garrity warning. There's a lot of background in regards to this as why the legislature put this in there, in regards to why an officer needs to respond truthfully, in regards to Brady Giglio issues. This is a very important issue that is addressed by the legislature and by our officers. Our officers, their primary position is to be witnesses on the stand, and if they cannot respond truthfully to their employers, that's an issue. So I believe this is clearly satisfies the jurisdiction of post counsel, and I would encourage them to proceed.
Thank you, Mr. Yockey. The statute, Mr. Willie, the statute is clear, and the purpose of Garrity is irrelevant at this point. We're moving forward. Thank you.
All right.
And a comment.
What's that? Who's
before
this?
we move to
Chief
the
Swanson
second
has
point
a comment.
Okay,
Go ahead.
Chief Swanson, go ahead.
Maybe it's, hopefully this is not inappropriate to bring up, but something that maybe needed to be considered, maybe it was and it's just not mentioned, is that Mr. Hoffman also admitted that he had searched records management systems and dispatch logs, which possibly could be a BCI violation. So just some food for thought.
Great, thank you.
Thanks, everyone. This is Dr. Checkers. I have a question regarding the claim of a PTSD diagnosis and brain injury. Could the counsel please hear what the professional training of Mr. Hoffman's therapist is?
I think we're okay. We can listen to that. Can we? Do we need to go? I don't believe we need to go into counsel session because we're talking more about his qualifications and not the patient. Is that correct?
Correct. That's all I'm asking. I'm just asking what the training is.
This is Mark. For clarification, just really quick.
Okay, one at a time. Please tell me who's speaking because I'm trying to track this.
No, you're good. This is Marcus Yockey. In regards to Dr. Checkett's stuff, we may proceed. I don't think we need to go into a closed session or anything because he's just asking about clarification to the individual.
And I'll respond just briefly on the qualifications of Mr. Hoffman's therapist. We at the hearing before the ALJ, we went thoroughly through his qualifications. He was qualified as an expert to testify to Mr. Hoffman's condition, and he has been seeing Mr. Hoffman for an extended period of time.
This is Linda Vitti. During the hearing, it was determined that, in fact, the therapist is, first of all, not a doctor, and secondly, he's not a psychiatrist or he's a family therapist. He's a family counselor. And the judge considered those defenses that were raised just now by his counsel, and the judge rejected those defenses and sustained the charges.
Okay.
And to be clear, that the...
Excuse me.
Go ahead.
Excuse me. This is Dr. Checker. So for clarification, the therapist noted is a family therapist. The therapist noted is not a neurologist, not a medical doctor, but instead a family therapist, correct?
That's correct.
Thank you.
All right. So to the second part of the
who's speaking?
Mr. Hoffman's argument.
Who's speaking?
This is Mr. Willie.
Please notify me who's speaking because I'm trying to track this. This is the chair. Thank you.
And this is Mr. Willie. To Mr. Hoffman's second argument, he simply did not have the requisite mens rea to be guilty of refusing to respond or to respond truthfully under Garrity. The questions that are at issue come during a 7-minute window of an interview that was almost 2 hours long. The questions were asked in a very confusing way, and by the investigators' own opinions, the investigation itself was not conducted in a very clear manner. And to add upon that, the therapist mentioned before testified that Mr. Hoffman has a documented TBI through the Department of Veterans Affairs. He is also being treated by that therapist for post-traumatic stress disorder, and the combination of those two ailments, make each other worse. And during that time, Mr. Hoffman was experiencing extreme stress from a variety of different sources in his personal life, in addition to the way that the investigation itself was being conducted, and for those reasons he was unable to recall details of conversations that when the questions were being posed of him. I'd like to give Mr. Hoffman a couple minutes to address the council on these points.
Go ahead, Mr. Hoffman, and then we need to finish up here.
Well, sir, thank you. Just wanted to relay at the time I was experiencing, like I said, quite a bit in a marriage situation that was going on. I was brought in about this time over this original Garrity warning, and my impression was in relation to a few months before there was a report that was in question and some other things about just a general report of a case that I had handled. So my impression at the time, when I had asked them what it was about, when they had read the Garrity, they told me it was about that, and so basically I kind of went forward with that due to those statements. And then I believe my interview was about almost 2 hours, and the initial part of that, I don't know how long it was, but I was pretty much counseled after that about some other things. And then at the time, I was also displaced out of my home, and then I was had to be moved again during this time. A lot of stressors going on with that, with the ex-wife as well. And then I also was getting reports on a couple cases where there was people telling me that they were being approached by one of my officers that was over me about they were asking questions, and I was never being told of any IA going on at the time. So it was causing me a little concern and stress on top of that because it was unrelated to anything about this. And then I just want to say that it's been a long road, but I've been trying to do better to treat the cases that I have and get treatment for that.
Thank you. Any questions for Mr. Hoffman?
I have a question. Sheriff Noel?
Sheriff Noel, please.
The question does not have anything to do with the Garrity interview. The question has to do with the initial investigation of the family fight. Reading into the alleged facts, you attempted to obtain the report yourself off of your Spillman system or whatever system it was. Is that correct, Officer Hoffman?
Upon the beginning of my shift, I usually checked activity going on. I believe it was the first of my weekend back, and it's common to check the activities going on in general, and so that was the only thing I had done, which was a common practice.
And
the question is, did you attempt to obtain the criminal investigation report that you were the primary suspect in? Did you attempt to get that from your computer system?
We just need to clarify one thing. Mr. Hoffman was not the suspect of the report, and secondly, the Box Elder County Sheriff's Office specifically looked for access to women, and they were unable to find any instance of Mr. Hoffman looking up this case. Although they did find many other, officers doing it, outside the scope of policy, they did not find a case of Mr. Hoffman doing it.
Thank you. Any further questions for Mr. Hoffman? Hearing none, I'm going to go ahead and ask for a motion.
And before we have that motion, I just want to preserve some issues for appeal. I understand that Post Counsel wants to get through everything, and I was not finished with my legal arguments. I just want to make clear that I'm not waiving any legal arguments on appeal. So.
Thank you.
And this
Chairman
is
Carpenter, Chad Soap.
Oh, go ahead. Who's speaking?
This is Chad. May I just I'm sorry, go ahead. I'm not sure.
Chad Soap, I was just going to say I need to recuse myself because Mr. Hoffman worked for me in the Garland Police Department at the time.
For the record, please show that Chief. So, all right, Mr. Name is recusing himself. Sorry, I got too many things going on here. Go ahead. Go ahead, Linda.
Okay, this is Linda Beatty. And with respect to the defenses that were raised with respect to PTSD and what is his other defense with respect to memory loss, I'm just reading item 18 in the findings of fact in the ALJ's decision. Quote, there is no evidence that Hoffman suffered short-term memory loss due to the extent that his superior officers were aware of the issue, nor is there any evidence that it affected his ability to do his job as a police officer. That's all. Thank you.
Thank you. Any further questions? Hearing none, I'm going to ask for a motion.
Christy Moran.
I have a motion. Go ahead, Christy.
I'd just like to accept revocation.
I have a motion from Christy Moran to accept revocation. Do I have a second?
Bruce Bailey, second.
I have a second from Bruce Bailey. Any further discussion? Hearing none, I'll go ahead and call for the vote. Those in favor?
Aye.
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 Any opposed?
Aye.
Hearing none, the motion passes. Thank you. Our next is James, I'm not sure how you say that, Hotelin? Hotelin.
Okay, with respect to the case of James Hotelin, is Mr. Hotelin or his counsel present? Okay, no one is responding. Mr. Hotelin and his counsel are not responding, so I assume they are not present on this call. The sustained allegations in this case are lying under Garrity and impersonation of an officer. The baseline guideline is called revocation. The range is 3 years to revocation. It's Class A and D. Post recommends revocation. Mr. Hotelin was employed by the Utah Constable Services in Washington County. There was a criminal case in this matter. He was found guilty of impersonation of Class B in Justice Court, but he appealed the charge, and impersonation was dismissed in District Court. He does have the aggravator of a previous post case in suspension. And I actually, that previous post case was failure to, I can't read my handwriting. Perhaps Mr. Yaki can help me with that. Failure to do something that he got a 3-year suspension for, and I can't read what I wrote.
Quite right. Just 1 second.
Yeah. It was in 2013. Failure to pay a fine, maybe?
While you're looking that up, for the record, Sheriff Pulsifer, apparently that he works for Utah County Constables, and then it says Washington County Constables. Is that any kind of conflict for you?
Yes, I need to recuse myself. He wasn't employed as the constable to Washington County, and I actually was part of the board as well as when the complaint came through.
So for the record, please show that Sheriff Pulsifer has recused himself.
If Ms.
Okay, and
wants to continue,
yeah.
I'll find it and provide the information.
I found it. I have it right here. It was failure to pay a fine over a fine or forfeiture fee. Okay, let me go back to my document. Give me just a moment to go back to that window. Okay. So on September 3rd, 2018, James Hotalin, a certified special functions constable, was investigated for a traffic violation and impersonating an officer. He was driving his silver Dodge Charger on I-15 and pulled up beside a restored 1971 Chevrolet Chevelle. Hotalin claimed the Chevelle had California license plates, was in and out of the HOV lane and cut him off. Hotalin said he drove up next to the Chevelle, shook his finger at the occupants, and told them to slow down. He said he did not remove his badge from his vehicle's visor and did not show the occupants of the Chevelle his badge. Hotalin said he never had his badge in his hand when interacting with the occupants of the Chevelle, and the occupants of the Chevelle claimed Hotalin flashed his badge at them with his hand.
We have some background music noise.
Please on hold.
Does someone need to mute? Yeah, I'm not sure what's going on.
Chris, you're going to have to just mute everybody. Somebody put their line on hold and we're getting their hold music. So, Chris, if you just mute.
You have been muted.
Just one sec, Chief.
Your microphone has been turned on.
Hello?
Okay, try that again. Try it again, Miss Beatty.
All right. Thank you.
Can you hear me now?
Do we need to do a roll call, or are we good?
I think we're still good.
Okay, go ahead then.
We're still good.
Thank you.
Okay. The occupants of the Chevelle claimed Hotalin flashed the badge at them with his hand, told them he was watching them, and told them to slow down. During a Garrity interview with Post, Hotalin said as the Chevelle began to pass him on the left on I-15, he moved his visor, which was down to the side, back into its original position. He said the Chevelle passed him, and he said something like, "Nice car." The Chevelle backed off, took pictures of Hotalin's vehicle, and reapproached him. Hotalin said the occupants of the Chevelle were angry. Hotalin said he never did anything. The badge was on his visor, and he moved the visor, but he never indicated to them to pull over. He never tried to initiate a traffic stop, did not get behind them, and didn't do anything along those lines. On December 14, 2018, charges of impersonation of an officer in a traffic violation were filed on Hotalin with the local justice court. He was found guilty on July 16, 2019 of both charges. He appealed the court decision, and district court was found not guilty of the impersonation charge. I'm not sure if that's exactly what happened or it was dismissed. In any event, that charge was dismissed ultimately. Hotalin failed to respond to the notice of agency action on March 16, 2020, in order to default was entered against him. I have nothing further.
So, Chief, really quick, this is Marcus Yockey. The information provided by Ms. Beatty in regards to the previous post-action, counsel action, was substantiated allegation of failure to pay over fine, forfeiture, or fee, which is essentially collecting bail money and then failing to turn it over.
Saying that he collected it and did not turn it over, correct?
Correct. And so that's just for clarification on that.
Okay, thank you. Are we privy to the findings on that? I mean, was there any criminal action that went with that?
It just said pending. The last notice, the last indication we had was pending. I believe I looked it up, and it was reduced. Give me one more second, and I can look that up.
Thank you. And if you could give us the date as well, thank you.
Yes, sir.
The date of the post-action was November 20th, 2013. I don't know the date of any other action.
Thank you, Ms. Beatty.
I'm sorry, post-counsel met on December 6th, 2016.
So the criminal charge I have associated with it, I believe this is the one that's linking up with it. It was dismissed. 2 counts were dismissed for theft and robbery.
Thank you. We'll go ahead and proceed unless anyone has any questions for Mr. Yockey.
Theft and robbery was dismissed. What about impersonation of an officer?
I'm just referring to the previous post-action, the post-counsel action. The impersonation.
Okay, thank you.
For the record, that was in 2013, not this case.
Correct.
Okay, I got it.
And in regards to this matter, so the current matter, we have an impersonation of a peace officer, disposition of 1/10 of 2020, was not guilty, but failure to use designated lane was found guilty.
Thank you. Any questions for Mr. Yockey? Seeing none, I'll go ahead and ask for a motion. Or hearing none, rather.
This is John Crowley. Motion to accept post counsel's recommendation.
I have a motion from John Crowley to accept post recommendation
Swanson, second.
For revocation, and I have a second from, who is that the second from?
Swanson.
Chief Swanson. Any further discussion? I'll go ahead and call for a vote. Those in favor?
Aye.
Aye.
Any opposed? Hearing none, the motion passes. Next is Kyle Maddox.
Mr. Maddox, or there's counsel for Mr. Maddox present?
This is Mr. Maddox. I'm here, yes.
Okay, thank you. Okay, Kyle Maddox, the sustained allegation with use of a controlled substance on 2 occasions. This is a Class C offense. The baseline is 2 years. The range is 9 months to 3.5 years, and Post is recommending 2.5-year suspension. Mr. Maddox was employed by the Washington County Sheriff's Office and was terminated. No criminal charges were filed. The aggravator is that there are multiple offenses. On December 31st, 2018, Kyle Maddox attended a New Year's Eve party at a home in Mesquite, Nevada. An individual at the party handed Maddox 2 THC edible candies, which he consumed. Maddox knew the candies contained THC. Later that night at the same party, a marijuana joint was passed to Maddox, who took possession of it, took a drag, and then passed the joint back to the group. While employed by the Sheriff's Office, Maddox tested with an outside agency. While employed by the Sheriff's Office, Maddox tested with an outside agency a few months later and disclosed the marijuana use during the pre-employment process. He was disqualified from testing for that agency as a result of the drug use, admitting the drug use. The next shift he worked after returning from that testing process, he was asked by his sergeant how the testing went. And it was at this time that he informed his sheriff that he was disqualified from testing with that outside agency because of his marijuana use a few months earlier. During Garrity interviews with both his department and Post, Maddox admitted he consumed 2 THC edible candies, knowing the candies contained THC. During the Garrity interview, the IA interview, Maddox admitted he possessed and placed the marijuana joint to his lips, but denied smoking a joint. During the post-Garrity interview, Maddox admitted he took a drag off the marijuana joint. Maddox was allowed to resign from his department in lieu of termination. No criminal charges were filed.
This is Alan Swanson. I have a question.
Hey, before we proceed, Sheriff Pulsifer, I believe you need to recuse on this. Is that correct?
That's correct.
Okay, for the record, please show the Sheriff Pulsifer has recused himself. Go ahead, Chief Swanson.
Chair?
I need a clarification.
Moore has something to say.
Okay, wait. Okay, let's back up.
Hello. Clarification. What I've got from Post here says that the offense is lying under Garrity and that the recommended discipline is revocation. And that is not what Mrs. Vitti just said.
Yeah,
and
that's the same thing.
That's not what it is. What did I just say? Hang on a second. Hold on.
Senator Moore has something to say.
We do have a revocation for lying under Garrity.
Copy that.
Should not be.
What was the lying under?
But he lied about it.
So you just let me know what the correct information is. I'm reading off the case cover sheet that I was provided, so just let me know.
I'm looking at the same thing for the record. It does show revocation.
Okay, so this is Marcus Yockey with Post Counsel. So on this, on Mr. Maddox, Kyle Maddox is who we're talking about, correct?
Correct.
So if you look at the notice of agency action and also the attached document for the ALJ's findings and conclusions of law, at the very end, it says count 1, conclusions of law, the charge that on or about April 9th, 2019, Maddox violated 536-211E by refusing to respond or failing to respond truthfully to questions after having been issued a warning of Garrity is proven by clear and convincing evidence. Count 2 and 3 were withdrawn by Post with the stipulation that they would not be refiled.
Yes, that's correct. And let me just clarify that. I'm looking at this and I see what happened here. This case cover sheet, I think that, well, it's inaccurate. The case cover sheet doesn't reflect what happened at the hearing. What Mr. Yockey just said is accurate.
So what is Post's recommendation for clarification?
So it would be, I'll let Director Stevenson.
Director Stevenson, it's revocation.
Copy that. Thank you. Any questions? So do we have a motion or any further questions first? And if not, then I'll move for a motion.
Sorry, this is Kyle Maddox. Do I have a chance to address
the
council?
Sorry, Maddox, go ahead. It's strange not being in the room. Go ahead, Maddox.
Okay, no problem. Yeah, so I just want to admit, I made a mistake with the marijuana use and everything encompassing that. I was involved with a person I should not have been when I was a police officer, and it's the reason I'm here. I am an honest person. That's why I'm here. I brought it up, and I wanted to do the right thing and take whatever punishment came with that. I understand my statements in the 2 interviews were inconsistent. I did not do that with the intent to lie. That was the only time I've ever used a marijuana joint. I don't know really how to describe smoking it or inhaling, but I'm not here to make excuses or anything like that. I just want to say I do, appreciate how everything was handled. I admit my mistake. I was young and not thinking wisely when I should have been in my personal life, and that ended up costing me my job. But I do want to say just my integrity is important enough to me that I would risk losing my job, which ended up happening. But I've learned a lot from it, and I just want to be able to put it behind me and move forward. I'm 26 years old. I still have a lot of help and a lot of good I can do as a law enforcement officer. So I would ask the council to consider a suspension rather than revocation. But I do understand what I did is, was a mistake, and I've learned from it and grown from it. So thank you for your time.
Thank you. Any questions for Mr. Maddox? Hearing none, I'll go ahead and ask for a motion. Can you hear me?
Mr. Chair?
Yes, go ahead.
It's Colonel Rathbone. Just a quick question. So the issue that we've got before us with regard to the Garrity, is that just contained to the discrepancy in the statement of one time he said he just put the joint to his lips, and the other time he admitted he actually inhaled or ingested the smoke? Is that the issue for the Garrity?
Yes.
Counsel, please. Okay, clarify.
Yes, that's correct, Colonel Rathbone. And just to clarify again, the actual charges of with respect to the controlled substance were dismissed by Post.
Does Swanson have a question?
Go ahead, Chief.
Linda, what's the range on this again?
I'm going to have to defer to Lieutenant Moore.
This is Director Stevenson. For Category A, the range is 3 years to revocation.
Okay. Well, then I would make a motion, a different motion, and go with a 3-year.
So I have a
Sheriff
motion
Noel.
for... Okay, so I have
Sheriff
a motion...
Noel, and I second it.
Okay, let me clarify the motion. I have a motion from Chief Swanson for a 3-year suspension, and I have a second from Chief
Noel.
Noel. Any further discussion? Hearing none, I'll go ahead and call for the vote. Those in favor?
Aye.
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 Do we have any opposed? Hearing none, the 3-year suspension passes. Thank you. It looks like Dave Passmore is not on the agenda. We'll now move to Benjamin Wolford.
Okay, Mr. Wolford or counsel for Mr. Wolford, are you present? Okay, I hear no response from Mr. Wolford or counsel for Mr. Wolford. The sustained allegations in this case is falsification of a government document, a Category B. The baseline is 1 year. The range is 3 months to 2.5 years. Post recommends 1.5 year suspension. Mr. Wolford was employed by the Department of Natural Resources. He resigned. The aggravator, after 14 years, the aggravator in this case was that there are multiple charges. On May 20th, 2019, Mr. Benjamin Wolford was investigated by his agency for falsification of a government record. The investigation disclosed that on 7 occasions, not several, but 7 occasions, between March 2nd, 2018 and April 29th, 2019, Wolford submitted meal allowance forms that were fraudulent to collect meal allowance. His daily log for the date that he submitted the 7 fraudulent meal allowance forms documented that he did not work the hours he claimed. On another form, no criminal charges were screened. He resigned from his agency. During a Garrity interview with his department, he admitted the SI-48s, which are the document he submitted, were fraudulent. And he indicated he didn't want to participate in the post-investigation. He failed to respond to the notice of agency action, and an order of default was entered against him. I have nothing further.
Any questions for Ms. Beatty? Hearing none, I'll go ahead and ask for a motion. Do I have a motion?
Well, Chief Swanson will go ahead and motion to go with what Post recommended.
So I have a motion from Chief Swanson to accept Post recommendation.
Second by Chad Soap.
And who was my second there?
Chad Soap.
Chief Soap?
Correct.
Any further discussion? Hearing none, I'll go ahead and ask for the vote. Those in favor?
Aye.
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 Any opposed? Thank you.
Hey, Chair.
Yeah, go ahead, sir.
Who made the motions, Director Stevenson?
So
For that last one.
the last one was no, that he seconded.
Motion was
Okay.
Swanson.
Motion was Chief Swanson.
Okay, thank you.
Second.
Noel.